Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IP Delhi and an intern at LEXIS and Company. So today I'll be talking about the topic dissolution of firm under Partnership Act, Indian Partnership Act. So section 39 of Indian Partnership Act defines dissolution of a firm. Dissolution of partnership between all the partners of a firm is called dissolution of the firm. So what are the modes of dissolution? Modes of dissolution are defined under section 40 to 44 of the Indian Partnership Act, and are further stated as section 40, which states dissolution by agreement. A firm may be dissolved with the consent of all the partners or in accordance with a contract between the partners. First, by contract. A firm may be dissolved at any time at the consent of all the partners. This applies to all the cases whether the firm is of a fixed period or at will. A dissolution was held to have taken place in the case of a partnership at will when the partners have not decided to carry on the business of firm from an agreed date. The second is by agreement. A firm may be dissolved in accordance with a contract between the partners. The contract provided for dissolution may be contained in the partnership deed itself or in a separate agreement. Section 41 states compulsory dissolution. A firm is dissolved by the adjudication of all the partners or all the partners but one as insolvent, or second, by the happening of any event which makes it unlawful for the business of the firm to be carried on for the partners to carry it on in partnership, provided that where more than one separate venture or undertaking is carried on by the firm, the illegality of one or more shall not itself cause the dissolution of the firm in respect of its lawful adventures and undertakings. So first is insolvency. The subsection is based upon the obvious principle that there must be at least two persons to constitute a firm. As already seen, on adjudication as insolvent, partner ceases to be a partner as from the date on which he is adjudicated as insolvent. Under section 42D, in the absence of the contract or to the contrary, to the adjudication of a single partner operates as a dissolution of a firm. The case contemplated, however, by this section is where the whole firm adjudged insolvent or all the partner but one are adjudged insolvent. It is clear that under these circumstances the firm is dissolved, there being no question of a contract to the contrary. The second is prohibition of a business. Where a partnership carrying a business in British Indian territory is dissolved by one partner becoming an alien enemy of and the Indian profits made after a dissolution of the use capital, payment being of course suspended during the war, an agreement may be void but not illegal. An agreement by way of wager is void but not illegal under section 30 of Contract Act. The Supreme Court has held that a partnership formed for entering into wagering would not be illegal, though it would be void. Where the business of a firm illegal from the very beginning, the agreement of partnership is itself unlawful under section 23 of the Contract Act. Section 42 of Indian Partnership Act says that dissolution on the happening of certain contingencies. Subject to contract between the partners, the firm is dissolved. First contingency is stated that is constituted for a fixed term by the expiry of that term, if constituted to carry out one or more adventures or undertakings by the completion thereof. Third, by the death of a partner. Fourth, by the adjudication of a partner as an insolvent. If the firm is constituted for a fixed period by the expiry of that firm, where a partnership has entered into for a fixed term, the partnership as at the end of the term is dissolved by the expiry date of the term, without any further act or notice, even when there is partnership for a fixed period. The death of a partner taking place during the continuance of the partnership period dissolves the partnership earlier. So the second is completion of a business. The partnership is dissolved after the business has been completed. Thirdly, the death of a partner. The effect of clause C of the section 42 is that the absence of a contract to the contrary, a partnership is dissolved by a death of a partner. A death of a partner means dissolution of the partnership. Fourthly, adjudication of a partner as an insolvent. A partnership is dissolved at the adjudication of a partner as an insolvent. Where a partner in a firm is adjudicated an insolvent, he ceases to be a partner on the date to which the order of adjudication is made, whether or not the firm is hereby dissolved. Section 43 says that dissolution by notice of partnership at will. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the other partners of his intention to dissolve the firm. Secondly, the firm is dissolved as from the date mentioned in the notice as date of dissolution, or if no date is mentioned, as from the date of the communication of the notice. Dissolution of partnership at will. Firstly, the point to note here is, but in order to dissolve the firm, the following conditions must be filled. Firstly, notice must be in writing. Notice must express the intention of the partner to dissolve the firm. Thirdly, the written notice must be given to all the partners. So the last section in dissolution of firm is section 44, which talks about dissolution by the court. Though there are certain circumstances in these circumstances the court dissolve the firm. First is insanity. Insanity does not dissolve the partnership if so facto confirmed lunacy provides a ground for dissolution by the court if other partner applies to dissolution. Like, this is a way to through which the partners can cease to dissolve the firm through court. Second is permanent incapacity. Whether any partner has become permanently incapable of performing his duties as a partner, any partner can apply for dissolution. The incapacity may be due to illness, mental or physical in nature, but it must be permanent. Thirdly, partner guilty of conduct to affect prejudicially the carrying on of the business. Fourthly, persistent breach of agreement. When a partner, other than suing, persistently commits breach of agreement relating to the management of the firm or otherwise so conducts himself in matters relating to the business that it is not reasonably practicable for the other partners to carry on the business in partnership with him, the court may order dissolution. Fifthly, I'll be talking about transfer of interest. When a partner has transferred the whole of his interest in the firm to a third partner, or has allowed his interest to be charged, or has allowed to be sold in the recovery of arrears and land revenue, or any other dues recoverable for land revenue, the court may order dissolution. Perpetual losses. When the business of the firm cannot be carried on a save at loss, the court may dissolve it. The whole object of partnership firm is to make profits, and if that object cannot be attained, it is needless for the firm to continue. Last, just and equitable. Dissolution may be ordered when, on any other ground, the court thinks it is just and equitable that the firm should be dissolved. So these were the sections relating to the dissolution of firm. I hope you understood. Thank you.